Hello and welcome to Friday Live. I am your host, Strata lawyer Amanda Farmer. It's Friday and it doesn't matter where we are, whether we're in a car, whether we're in a tunnel, we are still ready and raring to talk Strata. It is wonderful to be here with you live today. I wasn't sure it was going to happen, and I'm not even sure it is happening. This is certainly one way to do it, but it's too important. This week has been too important, especially for the Strata residents, the owners, the managers in New South Wales, to not be here and talking about what's going on in our Strata space at the moment. So I'm here. Yes, I'm in a car. Yes, I'm in a tunnel. That's probably the next 5 minutes or so of tunnel, and then maybe we'll have some actual light so I don't look like I'm hiding in the cave on you. I so appreciate you all being here. Yes, there is some breaking news. There is some fascinating and extraordinary law reform on the horizon for New South Wales. I'm going to talk about that a little bit today. But the deeper dive, the detail, the bigger discussion is going to be happening next week. That is something that I'm putting together for you, quickly putting together for you, as the team does so well in times of need. I'm going to let you know a little bit later in today's session when that is happening next week, when you can tune in, perhaps when I'm not in a car, when I'm not in a tunnel, and we can go deeper on exactly what these proposed reforms mean for you, whether you're an owner, a resident, a committee member, a strata manager. There's a big conversation to be had, and that conversation has only just started today, in the last couple of days. So if you're here live, let me know. I can see lots of live eyes there. Feel free to drop me a comment. Let me know where you are. If you too are in a car, I hope you're not driving it. If you're comfortable in your office or your home, I am jealous of you. I am currently heading out of Sydney after a few days of conferencing, and it's just so happened that the timing of all of this has meant that you've got me in the car today, and we've just come out of the tunnel, so now we have some light, and I no longer look like I'm hiding in a cave with a spotlight for those looking for me. All right, so what's happening? What's the breaking news? Do you want to know? Do you already know? Wednesday, 20th of November, just a couple of days ago, the Strata Schemes Legislation Amendment Bill 2024 was presented to New South Wales Parliament. And this is the next round of implementation arising from 2021 recommendations. Yes, 3 years ago, a whole raft of recommendations after some public consultation and some discussion. We have been, over the last couple of tranches of reform that's happened in New South Wales, been implementing those recommendations. And on Wednesday, this bill was first presented to Parliament. Lots of changes in this bill, but one big change I want to start with has been highlighted by the ABC in its reporting. Came out this morning. We have links for you. We've got a link to the bill itself. If you want to check that out, I am also going to share my screen with you in a moment and take you through some of the highlights of the bill. We've also got the link to the ABC News article. That's where I'm going to start today, because that's where I'm seeing a lot of the discussion that has been happening online. Commentators, you in my inbox have been popping in and letting me know what you think about this particular aspect of the proposed reforms. We'll take you over to that article. I'll just check those hellos. Denton's telling me it's Denton from Canberra. How you doing? Hey, Ju. Hey, Pauline. Jan in Warners Bay. Hey, Maureen. Hi, Gail. Thanks, guys, for being here. Philip is saying the greatest good news is Strata committee members need to go through training and certification. Yeah, that is an interesting one. Philip, and interested to hear that you've taken that as good news. Some others, perhaps, are not taking that as good news. Hey, Bill and Ben. Hey, Elle. Bill and Ben are saying, is part of the conversation the existing act is pretty much a no consequences act. And so we need to converse on what is changing to deal with that, because implementing more rules and regs that also have no consequences are of no consequences to resolving the lack of consequence. Love it, Bill and Ben. If you weren't here at the very top when we opened up the chat, I have said that I am putting together for you a webinar, a free webinar. You are all invited. It will be happening very soon. And I want to hear from you. This is a great opportunity today to let me know which parts of these reforms are confusing to you. This bill is not legislation as made. There is still discussion to be had in Parliament about this bill. So let's start talking about that now. And I'd love to take those questions and do that further unpacking when we have our deeper dive session next week, when I will not be in a car. Okay, that I promise you next week. Apologies if I am dropping in and out. We're going to do our best here with what we have got. Hey, Jan, Denise, Debbie, Shana, thank you very much. Josephine, Sean, and Jan. Jan saying, fantastic news. Strata is a business. You need to be skilled to run a business. Chris is saying committees need training. Denise is saying, me too. I don't know if that's an agreement there, or maybe you've lost me. This is interesting to me. One of the first things I saw this morning, I think after the ABC article came out, a colleague of mine had popped into my inbox and was referring to the Strata Committee training with some anxiety. I'm going to say some anxiety, maybe a bit of frustration. Does this mean that our committee members are no longer going to volunteer for these positions because they have to go through this mandatory training? I was interested to hear your views, and thank you for sharing them. I come here to this platform where we've been talking about some pretty in-depth Strata education for many years, and you're here telling me, yeah, I think we do need education and training. Perhaps it is those who are most educated, those who most understand the complexities of Strata, who agree that others too need a certain level of expertise and understanding. Okay, so what I'm going to share with you now is this ABC article. It's the place that I want to start with our discussion today. New South Wales Strata Watchdog seeks power to enter apartment buildings without a warrant, fine owners if common property is not maintained. So this article by investigative reporter Amy Greenbank. This article came out this morning. The bill was introduced to Parliament on Wednesday. I did get a call from Amy on Wednesday evening seeking my thoughts on this particular aspect of the bill, and that is what this article is covering. In short, New South Wales Fair Trading is seeking new powers to enter any apartment building without a warrant if there is suspicion the owner's corporation is not maintaining common property. The regulator will also be able to enter private apartments to inspect defects if it obtains a search warrant. A key consumer group said that it did not recommend the changes and had concerns the laws will have unintended privacy implications. So I just want to stop there and focus on this because a question has already come up here. I think it was here on the page about this difference between where fair trading can go without a warrant and without permission, and where it, or rather its representatives, can go with a warrant or with permission. So the proposal is that fair trading would have the power to enter the common property, so enter the building without a warrant if there's a suspicion the owner's corporation is not maintaining its common property. But if it wants to enter an individual lot, it will need either permission from the occupier or it will need to get a search warrant. So it is not the case, just to be clear, it is not the case that it is proposed to allow fair trading to enter individual lots without a warrant. You are forgiven for thinking that may be the case when you read this headline, but this is the distinction here in short. So new tranche of strata reforms, which the government is saying sets a high watermark for strata living in the state, a significant part of the bill, which wasn't really mentioned in the minister's speech to Parliament, is the proposed new powers to enter a building without a warrant if there are reasonable grounds to believe an owner's corporation is not fixing common property. Now, something I just want to make sure you're aware of, the delegates of the minister have always had the power, or I shouldn't say always, since about 2018 in this state, had the power to enter buildings and inspect common property in the case of brand new strata buildings. So that's been in Part 11 of our New South Wales legislation since 2018, that when we're talking about brand new strata buildings, where the strata plan has just been registered, the developer and the builder are still around, we need to fix original building defects, these powers to enter, to inspect, to issue orders, to search property, to destroy parts of the property in order to inspect it, to seize documents, to require people to answer questions, those powers have been there for a number of years, only in relation to brand new buildings. So this proposal is essentially to extend those same powers to our older established buildings, which are the buildings that most of us are living in, owning in, managing. So the extension of these powers in order to check up on a building's compliance with its Section 106 duty to properly repair and maintain the common property. So that's the extension of the power that we're talking about. Individual apartments could be entered with a warrant or consent, and unit owners would be compelled to hand over documents, consent to an interview, and have items seized in their home or face a fine. Fair Trading spokesperson said the new investigatory powers are only for the purpose of investigating and enforcing the owner's corporation's duty to maintain and repair common property. And that's what I've said is the Section 106 duty. That's the section in our New South Wales legislation. The government in my bedroom is not what we want. That is a quote. It will later come through from the Owners Corporation Network. Chief Executive Shari Driver, here it is in the article, said that the Owners Corporation did not request this change and said that she feared there would be unintended privacy implications. They're looking at their powers going much further than the front doors into their personal space. Ms. Driver said the new powers were modelled on those given to the New South Wales Building Commissioner, but now targeting individual apartment owners, not developers. Failure to comply with laws could result in hefty fines. There's a familiar face, looking rather happy with these proposed laws. When Amy spoke to me on Wednesday evening, this is what I said. This is an extraordinary intervention into private property, but I believe it is necessary. I spoke to Amy about the experience of some of my clients who come to me living in wet, moldy homes because their buildings are refusing to meet their legal obligations. They spend tens of thousands of dollars. So as I've said to Amy, and she's published in that article, these are powers that are being introduced to solve a very serious problem. If we're going to solve a very serious problem, we need some pretty serious powers. This is a problem that impacts the safety of the more than 1.2 million people who live in strata in New South Wales. And for too long, too many buildings have ignored their repair and maintenance obligations. This is, I think, the inevitable result. The government is going to intervene and, we expect, force these buildings to comply with their legal obligations. We wait to see how, if, when these new powers will be exercised once they're implemented. But I would expect that we'd only see them exercised in the worst examples of neglect, where the health and safety of residents and visitors is at stake. As many of you know, because you've shared with me, because you've worked with me, because I know what you're going through, until now, it has been up to you. It has been left up to you to engage in your own self-help remedy, to spend your money on lawyers and on litigation if you want your homes to be properly repaired. I think that's unfair. This new legislation seeks to correct that unfairness, and I think that's a good thing. These additional powers, at least from my perspective, are welcomed. The last thing we want to see in this country are deaths or injuries from the collapse of a neglected apartment building, which is what was seen in 2021 in Miami with the collapse of part of the Champlain Towers building. I think it's somewhat refreshing to finally see our government, at least in this area, stepping up and taking some responsibility, rather than what we were talking about a couple of weeks ago, and what I was giving you my opinion on was the frustration that arises when we often see our government simply place more responsibility onto owners to sort out their problems. That is not this legislation. This legislation is giving the government power to intervene, to take matters into its own hands. I expect those powers to be exercised in the most serious of circumstances. Heading over to some of your comments here. Scrolling back up because suddenly there's a lot of them, many of you here. Sean M is saying, I found the response from OCN disappointing. Yes, so I know I'm still sharing that article on the screen there, mostly to save you from my car background. The response from OCN was that they were concerned about privacy of owners, where government delegates are entering into private property. I was a little confused by that as well. I expect someone who doesn't want a government representative coming into their property to check out whether or not there is a repair and maintenance issue. I expect that person is either part of the problem, or that person has their head in the sand and does not understand or wish to comply with their legal obligations. I imagine most of the time where someone is having to give access to their property in order for there to be an inspection by these government delegates, that's going to be somebody who has been suffering. Somebody, probably the exact person who has lodged the complaint or alerted fair trading to this problem. And that person is going to be quite willing to give access to their property and indeed understand the necessity for giving that access if they want the problem fixed. This is evolving. This was new out on Wednesday. These comments are newly published. This is something we're going to be talking about for some time, gathering other opinions, gathering more information, and it's an evolving discussion, and I think it's important that we keep having that open discussion, sharing our opinions, especially as this legislation still remains in the form of a bill and hasn't yet been made. Bill and Ben saying fair trading already have those warrant powers, but for other reasons, so this is not a new idea. Yep, so I think I've covered that one off too. Bill and Ben. Georgina saying, brilliant idea to educate the uneducated. The proposed amendment to Section 37 is something all OC should know and understand. Definitely going to get to that one, Georgina. All right, I know there's a lot of comments there. I'm not going to go through all of them today. We're going to finish up with this article here. I've just shared with you some of the comments that I shared with the journalists. It's a problem that needs to be solved, and I'm sorry if this is the way, but I find it hard to see the downside, is what I shared with Amy. Alicia Fisher, the CEO of SCA, said that while privacy concerns were understandable, the provisions would effectively address critical maintenance and repair issues, ensuring the safety and functionality of common property. Well, you've heard that I agree with that view. That is not all that is proposed with these reforms. A number of recommendations that come from that 2021 discussion paper are proposed to be implemented. And I do want to share some of those with you as well. Wondering if my connection has settled a little bit or if I'm still dropping in and out, guys. I hope the audio is staying clear for you if the video is dropping out. We won't be going through everything in detail today, but there is another opportunity for that. That will be next week. I am going to let you know the date, the time, the where, the how, the when, how to make sure you can join me for that next week as we look in closer detail at these changes. And we will have had the opportunity by then. I will have had the opportunity to have a look at your comments and your questions here, to work through what is piling up in my inbox. I did have a couple of people today saying, Amanda, are you going to go through all the legislation today, this afternoon on Friday Live? I said, well, wasn't really planning to drop in, seeing as I'll be in a car, but we can cover off some of the high-level changes here now and go deeper next week. So what I will share with you now is the copy of the bill and a few sections that I've highlighted that I do want to make sure you are aware of. Just check I've got the correct version that I wanted to share here with you. Just one moment, hang in there with me. I've got one marked up here for you, and if I can share that one, that's going to be the better option. I'm not sure that's going to work for me today. Okay. I might try and do it this way. Sorry, guys. All right, we'll do it this way. I don't think I've got this one highlighted, but I'll do my best from memory to direct you to our key points here. So these are all proposed amendments. This is not yet law. We expect that this will become law in 2025. We're proposing to introduce the concept of accessibility infrastructure. I'm just going to try and get this in a different format for you because I don't think that that's going to be helpful. Oh, there we go. Now I can highlight it for you. Accessibility infrastructure, those are additions to the common property that will assist those with a disability to be able to access their homes. This is being introduced with a similar approval threshold, or identical, I should say, approval threshold to sustainability infrastructure. So if somebody wants to install accessibility infrastructure, it's only going to take an ordinary resolution calculated on a unit entitlement basis, similar to sustainability infrastructure. I think that's a good introduction here, not so controversial perhaps. You guys let me know if you disagree, but I think that's a good change that we should expect to see with all the same requirements about how this infrastructure and installations are financed and how they are approved. So in addition to sustainability infrastructure, we'll now have accessibility infrastructure. I'm going to skip over some of these that relate to brand new schemes and what the developer needs to do. We can have a closer look at those when we have our more in-depth chat next week. An amendment to expand the duties and obligations of Strata committee members. Some of you are already aware of this. You've mentioned it here in the comments. We're expanding the duties and obligations of Strata committee members to include the following: to exercise the members' functions with honesty and fairness, with due care and diligence, and for the benefit, as far as practicable, of the owners' corporation. Some of that's already in the legislation, but a function to act with duty to carry out functions with honesty and fairness, that's new. A duty to comply with the Act. a duty to only use or disclose information obtained as a member as required to carry out Strata committee functions, a duty not to behave in a way that unreasonably affects a person's lawful use or enjoyment of a lot. And this is the big one that many of you have been talking about, a duty or obligation to require members of the Strata committee to complete training and to make clear that a member who fails to complete the required training will cease to be a member of the committee. We don't yet know what form that training is going to take, how extensive or not it's going to be, whether it's going to be ticker box, whether it's going to be a course, who's going to provide it, what it's going to look like. We expect to understand all of that in time. Some of you already have let me know here as we opened up the chat that you think this is a good change. I think this is a particular type of audience that we have here on our live chats who are very receptive of education and training, who understand how important that is and how that improves your ability to assist your communities. And Strata managers, I know, who tune in prefer working with those committee members who have that higher level of understanding of what's going on. I don't think this is going to be the universal view. There are concerns that committee members will no longer put their hands up for these volunteer positions if this is what they're required to do. So we need to see what form this training will take. I think there will be a bit of a balancing act that fair trading will have to do here to make sure that the education piece is properly covered off in order to be effective, but does not deter our volunteers from putting their hand up to serve on committees. It's going to be a tough one. A few other tidying up that's happened here as well. I don't want to look too closely at these sections here today. That's something that we will come back to when we have our more detailed look. Amending Section 83 to require owners' corporations to provide additional information to lot owners with notices of levy contributions. So there's going to be some prescribed information that fair trading would like placed onto a levy notice, which we expect will essentially require owners' corporations to inform owners of their option for a payment plan, inform owners of other services they may be able to access to assist them if they are in financial hardship. So there will be changes to your template levy notices, Strata managers, that will need to include these requirements once we know what they are. An amendment to Section 85 relating to payment plans, allowing an owner's corporation to reasonably refuse to enter into a payment plan, and details of what constitutes a reasonable refusal. Oh, sorry guys, I've just lost my screen. And permitting the tribunal to order an owner's corporation to enter into a payment plan if the tribunal is satisfied that the owner's corporation's refusal was not reasonable. So that's new and interesting. For unpaid levies, to increase from 21 days to 30 days, the period before which an owner's corporation may be able to take action to recover an unpaid levy. Not sure that that's going to change too much in practice. As I've always said, owners' corporations are not, even though the media might have you believe, are not running off and immediately commencing court proceedings after they issue that 21-day notice, upping that to 30 days. Fair enough. I'm not sure that's going to have too much practical impact. So those are provisions to address this financial hardships that some owners may be experiencing, that we've been hearing owners have been experiencing. And I have to acknowledge that it's perhaps the case that financial hardship is only going to become more serious and more prevalent if we have buildings that finally come to recognise their repair and maintenance obligations and start raising levies, start entering into strata loans, start finally resolving to do something about their aging, leaking, damaged, falling apart common property. Of course, that's all going to cost money. probably going to cost less if you decide to do it rather than have the government direct you to do it. But it may mean that we will end up seeing more owners in financial hardship. So it makes sense that we would have these provisions being enacted hand in hand. Kiri is saying, what is the downside of learning about what you're supposed to be doing? Volunteering for a job means that you're prepared to do it properly. Denton saying, providing training to Strata committee members, especially new members, is certainly necessary to lift the standard of committee performance. Has there been any proposal to provide potential members with incentives to do this training? Will there be a competency assessment? Yeah, good question, Denton. So no incentives proposed in the bill as it stands. In fact, the only incentive is that if you don't do the training, you can't be a committee member. So perhaps the incentive being that if you want to be a committee member, then this is what's required. Those of us who are committee members may not quite see that our position as a committee member is all that glorious or glorified. But otherwise, no, I'm not aware of there being a proposal for any other incentives there. This is an important one. Section 106. We're extending the limit on the bringing of an action by an owner for breach of the statutory duty under the Act from 2 years to 6 years. So if you're not sure what that means, at the moment, if an owner's corporation fails to properly repair and maintain its common property and a lot owner suffers loss or damage because of that failure, the lot owner has 2 years to claim that loss and damage. That 2 years runs from the date the owner first suffered the loss. What's proposed now is that that will be extended to a period of 6 years. 6 years for a lot owner to recover their loss or damage if they have suffered because of a failure to repair and maintain the common property. This has been expected. I have to say, all of these changes are coming from recommendations. So none of them are much of a surprise to those of us who've been following what the proposed and potential reforms have been. This one's been on the cards for a while. I think it's a good change. It brings that period in line with other common law damages claims. 2 years is short, and I have known a number of owners who have sadly missed that deadline. I am seeing, I think Sean M is picking that up as well. That'll help a lot of owners. Georgina's saying, is the time extended to 6 years retrospective? Yes, Georgina, it will be. I think I've looked into this one previously. So it will still be from the date you first suffered your loss, or first became aware of your loss, I should say. So if you first became aware of your loss 3 years ago, you're currently out of time. But when the new legislation starts, you will then be within time. That should be how it works. There will be transitional and savings provisions when the act is made. So that will definitely be something that's worth clarifying. But my understanding is that that's how it works. If you're out of time now, but you're still within the 6 years, when the 6 years kicks in, then you'll be within time. Kristen saying the extension of time is necessary. So glad to see it. Yeah, I'm glad to see it as well. Okay. A Strata committee to give written reasons for refusing to approve renovations while the committee is exercising the delegated function of approving minor renovations. So we know in New South Wales, if a committee's given that delegation, they can approve a minor works application. Sometimes they're taking too long. The current law is that they cannot act unreasonably in approving or not approving these renovations. It's now the case, or it's proposed, I should say, to be the case that the committee must give written reasons for refusing. And importantly, if the committee has not provided written reasons within 3 months, the committee is taken to have approved the minor renovations. I hear too often from commercial owners who are running shops and trying to get new fit outs approved before they can open their shop. They're waiting months and months for Strata committees to approve their minor works applications. So I think this is a good change. And I say this from the perspective of a committee member. I know that there's a lot going on in buildings sometimes, but if that committee, it's incumbent on that committee, if it's accepted this delegation that we're going to consider and approve or not approve minor works applications, you can't just let them sit there and languish. You should be having regular meetings. There is no reason why these applications for minor works approvals shouldn't be going on the agenda for consideration and approval within 3 months. Owners are waiting, and often business people who are waiting to be able to open their new shops and new businesses, waiting for these approvals. Another kick up the bum, says Sean M. Yeah, I think there's a few of those in this. All right, a few more in there that I'm going to skip over and that we will have a closer look at when we have our more in-depth discussion. All right, I'm going to scroll down. I'll come back around to my notes and just check on what I may have missed, but I'm going to scroll down to some of this other legislation that's being amended. The reason that I'm doing that is because I want to point out this. The Fair Trading Act is being amended to essentially make sure that the agreements that owners corporations have with strata managers, for example, are covered by the Australian consumer law. This is important because it was not a week ago, or it might have been exactly a week ago, that the ABC was reporting on the standard form template contracts that it says the industry association is putting out there that apparently has unfair clauses in them. Lawyer Bronwyn Weir was pointing out that these are clauses that would be deemed unfair and therefore illegal under the Australian consumer law. It has been unclear whether the Australian consumer law applies to owners corporations to be able to find that these standard clauses are unfair and therefore illegal. I know this is something that the Owners Corporation Network has advocated strongly for a number of years, to make sure that the Australian consumer law does apply to owners corporations and the contracts they enter into, specifically with unfair strata management contracts in mind. That is what this new amendment, what this proposed amendment aims to do, is to bring these contracts made by owners corporations with others like strata managers within the purview of the Australian consumer law. And it means that those clauses in template contracts, like the limited liability clause that the template strata management agreement has, like the clause that allows strata managers to receive insurance commissions even if they don't place the insurance, those clauses are very likely to be found to be invalid under Australian consumer law. And once this amendment is in, we know that Australian consumer law covers our owners corporations and those contracts. This is a change that the Minister, you'll see if you go and have a look at the second reading speech in Parliament, was very proud of and quite focused on. And as I said, I'm conscious that there was a widely circulated ABC News article just last week talking about this. Obviously, this legislation has been drafted and in the works for quite some time. I'm not suggesting that it was drafted in response to the ABC article, but it is good to see that this has come out now so quickly after those concerns have been raised. It's definitely something that needed to be addressed. Okay, I'm going to stop sharing that one now and just check through if there's any other big ticket items that I wanted to make sure I raised with you. Sustainability infrastructure, you'll remember I mentioned accessibility infrastructure. That's a new term that is going to be introduced into the legislation, and that's about installations that facilitate a person with a disability having access to the common property or access to their home. That's going to have the same approval threshold as sustainability infrastructure, but there's also a bit of a change with our sustainability infrastructure it's now going to be very clear that a bylaw that bans the installation of sustainability infrastructure, by which we mean solar panels, EV charging, if there's a bylaw that bans that installation, that bylaw is prohibited. I imagine, I haven't gone back to the legislation, but it's probably going to say something like the bylaw is of no force or effect if it's a bylaw that seeks to ban the installation of sustainability infrastructure. That one being a response to exactly, sadly, those kinds of bylaws being proposed by communities. So I think that's another great change. Those are the big ticket items that I wanted to draw to your attention today while I am on the road, while I am probably dropping in and out. Sorry about that, guys. You've got the links here to go and have a look at the legislation, to have a look at the recent media attention. Please keep your eye here on the page for updates. There's a lot of discussion happening over on LinkedIn as well for our professionals. But I said to you that I'm putting together for you a more detailed session going through each of the reforms. I've skipped over quite a few important, impactful ones today, simply in the interest of time. But I'm going to be back. I'm going to be back round about this time next week. It will be, to be exact, next Friday, the 29th of November at 4 p.m. Sydney time. I'm going to host a webinar for you. Free webinar, you are all invited. It will be on the Zoom webinar platform rather than here on this system on Facebook. Zoom webinar, much more stable. I will not be in a car. I will not be in a tunnel. I will not be on the move. I will be at my desk for you hosting your Zoom webinar. New South Wales's Strata shakeup, what the proposed new laws really mean for you. Get registered. It's a free webinar, but you do need to be registered to attend. You can do that over at yourstrataproperty.com.au/webinar. Link here in the comments for you. I'm going to break down the key reforms that we are now expecting to take effect next year, 2025. Yes, we'll have more of a chat about this mandatory training that's being proposed for committee members. We'll have a look at this power for fair trading and its delegates to enter your lot, possibly without your consent. We'll have a look at unfair strata management contracts and how the Australian consumer law may be applied to deal with those. And we'll have a closer look at some of those other proposed reforms that we haven't yet touched on here today. I'm going to be keeping my ear to the ground. I'm going to be going through the many comments that I can see here. I've got to give it up dipping into those. I'm going to go through, see what the hot button issues are, see what's confusing you, what's concerning you, what you've got questions about, and make sure we can cover those off in next week's webinar. If there is a particular part of this legislation, if you've gone over and had a read of the bill, if you listened to what I've had to say today, if you're hearing from your neighbour, your strata manager, you're reading an article and you have a question or a concern about how this legislation may operate, may be applied next year, then post a comment here on the page, drop me an email, amanda@yourstrataproperty.com.au. The team and I are going to be collating those and making sure that we can address those for you in next week's webinar session. So that's next Friday, 29th of November, from a non-moving object. I will be coming to you live webinar. Get registered on Zoom for 4 p.m. next Friday. yourstrataproperty.com.au/webinar is the place to go. Sean's pointing out here to me in the chat, I think there's community title amendments as well. You're exactly right, Sean. All of those there in the bill, and we'll make sure that we give a nod to those ones at next week's webinar also. All right. You're all coming through now to tell me all the things that are also in the legislation that you'd like me to touch on. Not a problem. We'll make sure that we collate all of those. I will drop into your inboxes. I will drop in here on the page as well to remind you about that webinar and make sure you've got the link and you are registered to attend. Thank you, all of you, the many of you who have shown up here live. That's our very high level summary of what's going on. I'm going to wrap up. I'm going to give my driver a break from hearing about New South Wales Strata because we love it and we think it's really exciting, but I don't think everybody does. Have a fantastic weekend in Strata. Relax, get ready, get re-energized, get your flak jacket on. There's a lot coming, especially in 2025. But I'm here with you, and we're going to get through it together. That's it from me. Have a great weekend, everyone. Bye.